What's up, everybody? Welcome to another episode of the Shift Change Podcast. This week is real cool. Before I get into that, just a couple housekeeping things. At the end of every episode, I think I ask you guys to rate the show. I was under the understanding that it's rate each episode, but there's nowhere on each episode to rate it. It's you have to go to the show's page on Spotify and rate the entire show. So like Shift Change Podcast, just rate that if you're so inclined. What that does is that the more that happens, the more the easier it is for people to find on their streaming platform. So if they just search Shift Change, the more rates it has, I think that then my podcast of all the ones that are called Shift Change, which there's several, would pop up first. So that's where we're at in that deal. And then you can always share it too, because there's a triangle on the bottom that you can click so you can send to people if you're so inclined. If not, that's cool too. I'm not asking for anything, just clarifying. The chicken leg challenge tentatively set for August 12th. The reason why it's so far out is because chicken legs works every third day, and I didn't want to schedule it for the first day that he was off, because then he would give me some bullshit excuse about him being tired, and then that would be me taking advantage of him. So it's scheduled for his second day off where he's fresh. Time and place to be determined. And for those that have forgotten, because it's been a long time, the chicken leg challenge is every minute on the minute for 20 minutes, 5 push-ups, max air squats in the remaining minute, times 20 minutes, wearing a 20-pound vest. That's where we're at on that deal. 3. This intro is recorded on July 6th, so I hope everybody had a great 4th. I hope everybody still has the same amount of fingers today as they did on July 3rd. I hope England had a good day at work while we were off celebrating and barbecuing and swimming and doing whatever we were doing. And for those of you that had to work in public safety, thanks for that. Those people that did the parades, thank you. Those people that were on shift, thank you, while the rest of us were off. This week's episode, Kara McClure. She's an attorney here in town. She does family law and estate planning. Her and I were connected through a mutual friend, and from the minute I contacted her, she was all in on doing this, which speaks a lot to her. And I know that we all have different experiences with attorneys, but just keep in mind, bad attorneys make good attorneys look bad, right? So she clearly is an attorney for the right reasons. You can just tell it by visiting with her. She's in it to help people. And she gave up an hour of her day to give us a whole bunch of free advice. So if that doesn't speak and attest to her character, I don't know what does. But she did. So from the first conversation we had, she was real enthusiastic, asked a lot of good questions, all in, loved the project. And then we sat down, had a conversation, recorded it. Everything went well. A few days later, she texted me. She says, "Hey, man, I was just thinking." She appears to be an overthinker like the rest of us. And she says, "I'm not sure I clarified a certain point in this episode, so could you make sure to clarify it for me?" And that point is this. I asked her, I think, if I could just generate a will and testament basically on a napkin and say I leave everything to this person. I don't remember specifically what her answer was, but there was the caveat was 2 independent signatures and both signatures notarized. She wasn't sure if she said if she came off as you needed to have 2 independent signatures or have something notarized. It was both. Conditions need to be met. 2 independent signatures, both of them need to be notarized. And if she listens to that and I am off on that deal, I will correct it later, but that's how I interpreted her text message. So she wanted me to make sure that's clear. The whole episode is just basically about estate planning, meaning how to navigate the system when our parents die, if they have a will in place, if they don't have a will in place, what's the difference between a will and a trust, what we can do as adults to get our stuff ready for our children, because we're all going to get to the same place, and it seems to be advantageous to navigate if we get our stuff in order. So let's all be adults. I know that we think that if we're in our mid-40s that the end is a long ways away, but that's not necessarily true, and we know that deep down. So the sooner we have our stuff in order, the better. She gives contact information at the end to contact her if you're so inclined. She will be my go-to person when it comes time for my family to get our affairs in order, and hopefully that's sooner than later. But this is an adult thing. It's part of being adults. Let's just do it. It's going to make life easier for our children. And if you've got parents that are, to that point in life and maybe they haven't gotten around to getting their stuff done, this would be a good episode for them to listen to or for you to share to kind of get them moving in the right direction to get their affairs in order. So it's a great episode. Looking forward to listening to it myself. So if you got any questions, as always, you know how to get a hold of me. Enjoy. Work hard. Be kind. Bye. I kind of feel like you're on the stand. You've been on the stand before?
Yeah, I do a lot of child representation, so I end up testifying too.
Really? Mm-hmm. Do you get nervous?
I used to, but I've done it enough now, not so much.
Is it more of a performance versus how do you prepare for the stand? Let's get into that right. How do you prepare for it?
Usually if I am taking the stand, I have done a written report. And so then what I do before I testify is I go back through that written report. I wouldn't say I have it memorized, but I've got the main points, strengths and weaknesses of a family, stuff they need to work on, recommendations. Those points I have pretty well memorized. I'll go back through my notes, which is what I use to base the report to make sure that there wasn't any little things in there that might come up that I need to know, or the number of times I met with each person, or especially the kids, where I met with the kids. I'll make sure I have those facts down.
I assume it gets better as you go,
yeah.
You get more. I was a witness for the state a couple months ago, and I had to take the stand, which, being up in front of people isn't necessarily difficult, but there was always that in the back of my mind was, what if this lady tries to trip me up and I stutter and I sound stupid, and then all of a sudden I'm not credible as a witness and this guy gets off.
Right.
For something stupid.
Right.
So,
yeah.
For everybody listening, I'm sitting with Kara McClure, who's an attorney here in Adel, and she's agreed to talk to us today about how to get our stuff in order towards the end of our life, and how we deal with the legal hurdles of when our parents pass, and then, of course, getting our stuff ready for our timely or untimely demise. So thank you for being here. I know that this is weird in this day and age when somebody calls you up and says, hey, you don't know me, but would you like to sit down in your office and give us some general free advice? So thank you for doing that.
You're welcome. I'm happy to help.
Tell us a little bit about yourself. You're from around here?
I am from Southwest Iowa. So I grew up in Corning, and then I married into a farm family. So my husband grew up around here.
Right. Where'd you do your undergrad?
Iowa State.
Oh, right. Cyclone. We're Cyclone fans in my house.
Perfect. I like it.
Half of us are. Half of us aren't.
I like the half that are Cyclone fans.
That would be my son and I. Where'd you go to law school?
I went to law school at Iowa, but I'm still a Cyclone fan. In-state tuition.
Yeah, sure. Mm-hmm. You got to.
Yep.
That's great. And what kind of law do you practice?
I do a lot of family law, and then I also do estate planning.
Oh. Well,
I do a few other things, but that would be the bulk of my practice.
Sure. Well, perfect. You're the perfect candidate to talk to us about estates. One of the things that I've always felt like when somebody says the word estate, that means you have $1 million and you have basically a gated house, like what we see on TV. Is that true? That's not true, right?
That's not true.
What is an estate?
So an estate estate planning is what you talked about as we were starting this, needing to have a plan for what happens to your assets after you pass, whether you know it's coming or whether you, like you said, it's an untimely demise. You need to have a plan for what happens. It might be really simple. It might be more complicated. If you have children who are minors, then you really need to make sure you have a plan for them to make sure everything's taken care of.
So an estate is just basically a term meaning your stuff.
Correct.
Okay. So the number one way I think that we feel we understand to prepare for that is to have a will and testament. Is
Yes.
that the proper terminology? So what exactly is that? And how does that differ from a trust?
Okay.
Is that the same?
It is not the same thing.
Okay.
So the will is what controls when you pass. It says who gets your assets and who is in charge of making sure your will is followed. So the will names an executor or multiple executors, and that is the person who's in charge of following the terms of your will. They would be the one in charge of if your estate has to be probated in court. They would be the one working to make sure that that happens and happens properly. They start to liquidate your assets, whether it's 401ks, pensions, life insurance, home, those types of things. They do all of that, and then they make sure that the money goes to the right people. A trust can be similar, but that is created usually while you are alive. And then the point of the trust would be to bypass probate. You're trying to avoid probate for one reason or another.
What is probate? What does that mean?
So probate means after a person passes, whether you have a will or not, if it's a married couple, it's usually at the death of the surviving spouse, not at the death of the first spouse. If it's a single person, then it's usually at that person's passing. If they owned a home, then it's selling the home. To be able to sell the home, you have to have authority to do that. And most likely nobody else's name is on the title after the surviving spouse or a single individual. So you have to have permission from the court to sell the home and have authority, get the assets from it, the net sale proceeds, and then give them to the beneficiaries. So that's what you're starting to look like, why you would have to go through probate. You have an inventory of all the person's assets, liabilities if there are some, and then you start to work through the process of liquidating and getting those assets to the right people or the cash form to the right people.
And the state puts, okay, let's back up. So let's say the will. The guarantor of the will is the person that's in charge of making sure the will is followed. So if you and I sit here and draft a will and I say, I want so-and-so, who's the best person to be that executor? Is it necessarily the spouse?
It really depends, and I know that's a great answer, right?
Family
people
dynamics.
Are going to choose their spouse. Sometimes as people get older, it does become a question. Is there dementia at play? Is there other needs at play? Most people are going to choose their spouse. So husband and wife, or whatever the relationship is, they choose each other first.
Sure.
But you're always going to name at least one contingent or even a second contingent. So there's a backup plan in case you are the surviving spouse and the person's already passed, or the person's unable or unwilling to serve for some reason. So with older people, maybe they're still naming a spouse first, but then maybe they've got adult children that they can start to name as their backup people.
So we draft this will when it says that. I think is there some sort of myth that the will names a specific person that's going to get a specific thing? Let's say a baseball card. Let's say, right, like there's a Honus Wagner baseball card in my grandpa's basement or my dad's basement, and he dies. But nowhere is it written, Jason gets it.
Right.
Is that what wills do? Do they list out each individual thing and says, I want my son to have the Honus Wagner and I want my daughter to have this? Is that...
Not the way we do it. Some of them can. And what I usually say with some of those personal property assets, more the sentimental things. Now that may have some value to it, so it could be a little different. But usually the way we do our wills is it's always in our Article 4, for example. We leave a personal property list, or our will authorizes you to leave a personal property list. And all it does in the will is says, if my executor finds a personal property list at my death, the executor needs to follow it. And then it needs to be signed and dated. And we emphasize that to make sure it's legit. So then I'll give people, when they sign wills with us, a form that they could use if they want for a personal property list. And you could put something on there. I tell people it's more sentimental value things, Christmas ornament collection, family jewelry, artwork, stuff like that. Not usually something that has a high dollar amount. We're not talking a gold coin collection maybe or anything like that. But things that, for whatever reason, have that sentimental value, you want to pass that on. Sign it, date it, have it on your personal property list, keep it with your other important papers. Executors should follow it. The advantage of not putting it in your will is you can change it anytime, and you don't have to come back to me or another attorney to make changes on that personal property list. You just keep doing it yourself, sign it, and date it.
Oh, so you can add in as you go.
Exactly, because it's just that personal property. So it can't be anything with a title, can't be real estate or a vehicle or anything like that.
Okay.
Can't be anything with an account number. So you can't pass your bank account, your retirement accounts, or anything like that way. That's why I kind of say it's more that sentimental or family heirloom value.
And that would prevent somebody from saying, hey, listen, Dad's dying breath was, I get the Honus Wagner. And
Right.
in fact, I never said that at all.
Correct.
So that prevents that kind of contentious
Correct.
at the end. So let's say, I'm trying to figure out how I want to word this. So I die today. We have nothing in place right now.
Okay.
And today is my day. What kind of legal hoops is my wife going to have to go through if we don't have at least the basic will and testament in place?
Okay. So the first thing that people need to make sure that they do is they need to check how they have, most people, if they own a home, how they have their home titled. And the goal for most people would be, and this is even outside of a will, is that you would own it as joint tenants with full rights of survivorship and not as tenants in common. And that's a whole phrase in Iowa.
Okay.
So that the goal is if you have passed, but your wife is still alive, there's really nothing else she needs to do for the home, which is one of the largest assets people have, to make sure that she's full owner. Now, if she would go sell it later, she might have to do an affidavit of surviving spouse to say, Jason passed, I'm his widow, we were married at the time of death, now I own it outright. But it's that simple. The other thing then she would have to start doing if there was no will is she would have to look at what assets are remaining, if her name's on them or not. And if her name's not on them, if she has to probate anything, it would be intestate. So intestate means you passed without a will. Okay. So then there's laws in Iowa and every state on what does that look like. They have this whole family tree that they illustrate, and it looks at your wife.
Do those laws protect the widow or the widower, or
Correct.
do those laws protect the businesses and the assets? Meaning, let's take my truck for example. Okay. I don't know that Lindsay's on my truck.
Not uncommon.
Okay, so do those laws? So let's say it happens, and now she's left with my truck. My name's on the title. I don't have a will. Right. What kind of problems is she going to run into? And do those Iowa laws protect her against the companies that I owe money to, or do those laws protect those companies?
It probably, if you owe money on the truck, or if there's a way that somebody can try to seize the asset of the truck, then those companies have to go through a notice procedure as well to try and collect on it. Ideally, Lindsay would be the one protected. She would, if her name is not on the title, it depends on the value of the truck. Yeah. But there's kind of 3 different levels of estates in Iowa, and depending on the value of the assets. So it would be really just looking at what are the assets that are not protected, that her name was not on. Does there have to be probate? What's the total dollar amount? Depending on the dollar amount, this is the process you can take. Usually for a vehicle, it's under $50,000. Mm-hmm. So then she can do, again, an affidavit saying, I am the widow, the value of the assets that we didn't have a will, the value of the assets are under $50,000, and now I'm just asking for title to it. And she should hopefully be able to proceed with that. Again, it would depend on the whole asset value and go forward from there to get it. You have to give notice to creditors. So that's where the law comes in to protect people.
And that's like credit unions and credit card debt?
Yes.
Yes. Is that what we're talking? Or
and state of Iowa,
loans?
Right. State of Iowa has the right to have notice. It's called the Estate Recovery Program, to make sure if anybody receives state benefits, that's the state's way to come back in at that point in life and try and claw back some money if they feel they were owed it. Sure. So you have to get clearance from the state to say we're not owed anything.
So there's a lot of, this sounds messy.
It's some hoops.
This sounds messy.
Yeah.
To you, I'm sure it sounds very like.
It's procedural,
right. But. Because there's always, somebody's got to always have their stuff in it. Like you always got to file with somebody. And then, So how long, let's see where we're on. So is any will binding? Like if I write something on a napkin and say, I, in sound mind and body, declare that my son is the guarantor of my will when he turns 18, and I sign that on a napkin and I put that in our fireproof safe, and then they recover that after my demise. Is that binding?
No, you need, in Iowa, you need to have 2 witnesses to that will.
Okay.
The witnesses cannot be anybody who receives anything under your will.
Oh.
So I know. So that's an important one because usually you turn to the people close to you, which might be adult children. Well, if they're going to end up being your beneficiaries, then they're excluded because they have an interest in your will. And then there's a big question if they influenced you to give everything to them.
Where's the wills kept? Where are wills kept?
So back in the day, I don't want to say back in the old days, but back in the day, a lot of law firms, if you would come to me and sign a will, we would keep it in a fireproof safe. But that gets harder as people live longer.
It's a big
people
safe.
Retire. It's a big safe and you lose track of where people are. But then it becomes our job to say, well, we can't throw the original will away. Original wills matter.
Oh, they do?
We can't throw away the original will because we can't find the person and we don't know if they've passed or not. So our policy is we'll make copies for you, but we will also give you back your original. And then we keep a note in your file that says, Jason signed wills with Kara on June 27th, 2024, and put the original in his safe deposit box at X bank or in his gun safe in his home. So if we get a call in the future from Lindsay, she says, I know Jason signed a will. I don't know where it's at. We'll say, well, as of June 27th, it's in your gun safe at home. So it helps to narrow down where it's at.
I'm really kind of shocked right now that in the age of electronic and paperless and cashless and everything less, that having a paper copy of this document is like of importance.
I know.
Isn't that something?
There's not a lot of things anymore that the original matters, but the will under Iowa law is one of them.
Does it matter if, okay, listen, I can't find the original, but I have the copy. Is that a difference? Would they say, I'm sorry, this isn't the original because I can see a watermark or whatever, so we can't honor this?
I think you would still, if you have to probate that, I think you would still file that in, when you go to probate in court, you would still file that and say, we don't have the original. This is believed to be the last known will and testament based on the date, and see if anybody comes forward to challenge it.
But
you'd have to disclose that.
Sure, you'd have to say, listen, I can't find the original.
Correct.
This is the copy of it. So how difficult is it, and this is the example I'm going to give, is because I have a friend of mine whose parents passed, and he was an only child. And so his dad said to him, listen, I don't have a will because you're the only kid.
Yeah.
Okay, so it's all yours. That's probably not true, right? And so here's the story is that he went in to try to shut down his dad's cell phone account. And they were like, I'm sorry, you're not. And he's like, I know he's dead. Here's the death certificate.
Yep.
Here's my identification and my social security number and my identification that says I am his son. I am he. He is no longer living. And they're like, sorry. Apparently a will would have played a role in that process to get his cell phone service shut down. Is that a thing?
It probably, in the will, it probably would have named him as one of the contingent executors, if not the primary. So then he could have probated that in court. It depends on your company. He could have taken the will maybe to...
There wasn't one, is what I'm
saying. I know, but if he'd had a will, maybe the company would have accepted the will to see he would have been the executor. Otherwise, it's opening probate to be officially named executor by the court. The court issues what's called letters of appointment, and that's the document that banks and usually businesses require to see that you have authority to act to start shutting things down.
So he would have had to file something with somebody like you. That's it, right?
In court,
how do you start the probate process?
The easiest way is to meet with an attorney.
Right. And so you file the paperwork, and then the law, who decides that now, let's say Verizon Wireless.
Yep.
Who gives Verizon Wireless now authority to shut that account down?
So once you file the will in court, you petition to have the will accepted in court, and then you also request that whoever is named as executor in the will, if that is still the possibility, person's alive and willing to act, that the court name that person as executor.
And then they go back
and shut it down. The court issues the letters of appointment, and then that's what your friend would have taken to Verizon to say, I am now the executor. I have full authority over my dad's estate. I'm shutting this down.
How long does that process take?
It depends on the number of creditors, assets, if you have to sell real estate and stuff like that. But ideally, you're done in 9 to 12 months.
That seems like a long time.
It can. I mean, I could say 6. It really just depends.
And I'm not saying that in any other relation other than if you want to shut down a cell phone account that is somehow automatically withdrawing payment from your account, 9 to 12 months of that, or now you're building up 9 to 12 months of, deficient payments or whatever on anything, truck, phone payment, cable, internet, whatever. Do they have to go through that process with every account?
Yes, but it doesn't take 9 to 12 months to do that part. It's 9 to 12 months start to finish from when you file to probate to when it's completely done and the beneficiaries hopefully get their money. So he can start to shut down accounts as soon as he's appointed as executor. That doesn't take as long.
So that's the process. So you don't have to file for each individual account. You're just, when somebody files for probate, and I apologize for my ignorance, when you go through the probate process, that is purely just to name X person as in charge of shutting everything down now. So not each individual account goes to probate.
Correct.
Yes.
Yes, okay. I'm sorry, not each. The one estate goes to probate. So it'd be the estate of Kara McClure.
Yes.
And then my husband would, and then we give notice to creditors. And that's a 4-month process. They have 4 months to come in and say, MasterCard has 4 months to come in and say, hey, there's an outstanding bill. We're giving notice that before you pay beneficiaries, you have to pay us, something like that. And you have to resolve all that. So that's why there's automatically time built in that it takes to close it. But it's one estate. And then you give notice to all creditors and publish notice, and they have that amount of time to react to it. But the executor can start to close accounts and liquidate accounts and do what's needed.
And they will get something saying that.
Yep.
That they have to basically probably send in with the death certificate, which is one thing that I realized when my dad passed a couple years ago is everybody wants that death certificate.
Yes.
And so you have to get basically 20 of them.
Yes. Of the certified or whatever copy, the real version of it. Yeah.
At about $20 a pop or ish, whatever it was. So you're talking an unexpected death with the expenses of an unexpected death versus maybe something that's coming. I'm sure that's different. But the point of that is that one death certificate, you can't just scan into your computer and email it to these companies. It sounds like you have to have, I need it mailed to me or sent to me somehow, and it has to be some sort of version of the original. It just seems super messy.
It is. So, and I think that's one thing people don't always know. I think a lot of that paperwork happens usually at the funeral home, and maybe that's where the question is, how many death certificates do you need of the certified copy that most companies want? It's a good idea to get multiple for what you just said because it takes a while to reorder them.
For sure. Mm-hmm. And so one of the interesting things that I learned when my dad died was, and he had a will, but it basically named his surviving spouse as the beneficiary or the executor. And then if she didn't want the job, then it was me.
Yes.
And okay, we all accepted that. I never laid eyes on it. But what started some family drama was the assumption that in that will was the Picasso that none of us knew about, and or the pile of gold that's buried in the backyard, or I'm just for sure that I'm getting something, and I think that, or maybe he left us a trust, and I air quoted trust, meaning there's some sort of pile of money sitting somewhere that when I turn a certain age, I am now able to get that. And is that stuff kept in the will? The will just sounds like it just gives people legal authority to handle my affairs when I'm gone. Is that?
It can be that specific.
Because we talked about that before, with
the personal property.
Sure.
Yep. But if there's something that has more value to it, or a specific account or asset or something, you can put that in the will. A person can choose to do that if they want. Or maybe there is that gold coin collection. I would maybe argue that shouldn't go on a personal property list. There's probably some value to that. So let's put that in the will. Or if it's not, assume it's part of what I would say the general estate. Where you're making sure everybody's getting their fair share out of it in whatever shape that is, whether it's liquidated or each person gets one coin or whatever it is. But the trust part of it, there's different ways you can do a trust. And the most common one is somebody with young children.
Okay. Let's use me as an example.
Okay.
I have 4 minor children.
Yes.
I have, the only thing that I know of that I have for them is an IRA. that
Yes.
I have listed that all 4 of them as beneficiaries. So my assumption is that when I die, it gets split up in quarters.
Yep.
So a quarter each of them. Now, however, that is through me and my financial company that I went through to set this up. I don't have anything on paper that says that in a trust or a will. But let's look at a trust, and does a trust avoid some of the messiness that we just talked about with a will? And if you don't have it, like, is a trust better? Is it more airtight as far as legal proceedings go? Or is it just semantics?
It's just semantics, in my opinion.
Okay.
You could probably talk to another attorney who say it is better or it's the only way to go. The biggest takeaways from it are you have to, if you do the trust correctly, and depending on the type of the trust, you have to retitle everything into the name of the trust to have the benefit of it.
Okay.
One of the biggest benefits of a trust is to avoid probate and the cost of probate and everything else. So to get there, then you have to retitle your house. It's not as joint tenants anymore. It's in the name of your trust instead is the title on it. And you would do the same with a lot of your accounts and assets. Otherwise, you still have to have a will and probate. So the whole point of that would be the retitling. It gets more complicated. And the question is it worth that and having to title everything in a trust and keep all of that set up properly versus just going through probate?
There's probably a cost involved in retitling.
So there's a higher
right?
cost to doing a trust than a will, which probably about offsets maybe what you would do for probate fees. I'm not sure, but
it might be a wash.
It is. So unless you are trying to avoid federal estate tax or you have some type of generational wealth, it's not always needed to do a trust right now.
If I were to do a trust, do you handle the retitling of back into a trust name?
We do as much as we can. There's certain things we can't do, which might be working with financial planners and things that we would say, we'd give you a letter and say, here's your next steps. But we would work on retitling the real estate and doing all the other things that we have to do to make sure it's all set up properly. But there's other types of trust that are more common. So like with young children, if you would leave that IRA to them in their individual names and they're under the age of 18, it becomes a problem because minors can only receive somewhere between, I think it's $15,000 and $18,000 outright if they're under the age of 18. Oh. And then it has to go into a conservatorship, which is run through the court. There's reporting requirements. It's very restricted on what they can use the assets for until after they reach the age of 18. And then once they're 18, boom, it's theirs. Whether you think they're ready for it or not, the conservatorship ends because it was set up because they were minors. So another way to do that is to put a trust in your will. So the trust wouldn't exactly exist right now. It would get set up and funded. The idea of it exists. And then it would get created and funded when you pass. So then you would actually work with your financial planner to retitle the beneficiaries to your trust instead of to your kids outright. I know. So there ends up needing to be some connection with the financial planner and the estate work to make sure everything's done correctly. Under federal law, the plan administrators on your beneficiary accounts, your IRA, 401k, pension, life insurance,
a lot of us have IPERs.
Exactly, IPERs, they have to pay whoever your beneficiary is. So if
regardless if I have a will or a trust,
they have to pay who it is.
My wife. Okay, so if you only named one, so Lindsay obviously is the beneficiary of most of my financials, so like my IPERs and my current retirement thing.
Yep.
She is not a beneficiary of the IRA that I've set up for my kids. They have to pay her regardless.
Correct.
Like if I have a will or a trust, it doesn't matter. I've named her as the beneficiary. Life insurance, she gets it all.
Correct.
For whatever reason, God forbid, she's gone.
Okay.
I don't have a second one named.
Okay.
Where does that go?
Pays it to your estate at that point in time.
Okay. Then we're back to the estate thing.
So you're back to your estate. So there would need to be probate at that point in time.
So somebody of authority is going to appoint a judge, probably. Is it who does this?
So somebody would have to request to probate your estate in court, and then somebody is named executor.
Gives that authority
and
to
then
whoever.
They approach whoever has, did you say IPERs? Whoever, They would approach IPERs then and say, okay, so it named Lindsay, she has already passed, and the next beneficiaries under Iowa law or in your will if you had one, would be your kids. So we ask that it get paid to the kids.
And somebody has to prove all that.
Yes.
Like, which sounds like a paper trail nightmare. So now I have to come up with mom's death certificate. I have to come up with dad's death certificate.
Yes.
I have to come up with the original will that says this, and then I don't know the password to dad's computer, so I can't get on there, and I don't know his password to the bank account. So let's talk about that.
Yep.
Do we need how do people? This is more overwhelming than I thought, and it's not because you're not doing a good job of explaining it. It's because the law by nature is muddy. It seems like it anyway, and thank God for people like you that can sort that out, that have the brain power to do that, because I don't know of anybody that, other than attorneys, that could do this. It's certainly a gift, so thanks.
Well, thanks.
But it's real muddy. So, okay, I'm dead, and you can hack my entire life with about 3 versions of the same password. Okay,
you're not alone.
But nobody knows what it is. So how do they gain access to my accounts? I assume it's the same process. I show them the death certificate. Lindsay shows them her ID that says that she's next in line to take over. Because a lot of us do, like on my day off, I'll set up an account with something. Let's say MediaCom.
Yep.
And the internet's under my name. And then, okay, but now I'm dead. She doesn't know the MediaCom account.
Right.
Or bank accounts. Like Lindsay handles the business in our house financially. I don't know our bank account. I ain't gonna lie to you. Should there be? The answer to this is yes, I'm sure. Copies of everybody's passwords somewhere.
So there should. So, for example, when we do estate planning here and you sign your documents, wills, powers of attorney, we'll send you with the folder. And then I'll remind you it's a good idea to put some of those documents in there. Declaration pages for life insurance, a copy of a 401k statement, something like that, just so people know
that have account numbers on it.
Yes, yeah. Of what's out there, what exists, what has to be liquidated. Passwords would be another good thing. So that's the proactive side. While you're still in good mind and spirit and you can collect all that information, put it all together in one spot and then people can find it. The alternative is if that doesn't happen, and I mean, not everybody's good at that. I'm not even good at that. And I do some of this for a living, right? Yeah. So I know, I'll admit that. So the option is then that person, whoever your executor is probably spending a decent amount of time on the phone talking to MediaCom, talking to the bank and saying this person passed, here's a death certificate, and then liquidating and stopping payment and accounts or switching account names or something.
Do you know, just from experience, like how reasonable are people on the other side, on the other end of the phone about, right? Like, I feel like there's an opportunity to take advantage of people in times of death. And I'll give you an example. And this is a bad example. My best friend is eventually going to die of brain cancer. Okay. They're in the process of getting all their stuff in order and they're doing a great job. Okay. One of the stories he told me was he was the only person on the truck, and so he called and said, "Hey, listen, I need to add my wife to the truck payment." And they immediately said, "Well, that's fine, but we'll have to refinance your truck." And he's like, "Really? Does that make sense to you? Like, we have to refinance this whole truck just to add my wife to the thing?" So that right there told me, it kind of felt like they were making that up. And in a way to refinance at a higher interest rate or whatever to try to get some sort of advantage, right? Which automatically annoys me.
Yep.
But we also understand that most places are businesses and they're trying to make money and that's their job. It doesn't matter how nefarious they're going about that.
Right.
And so that's annoying to me, the fact that if my wife... Now, he basically said, "Hey, listen." And I think the conversation led to maybe maybe they've heard this before. Maybe they're going through a divorce and now he wants her name on that truck. So now it splits halvesies. So now she's got half the debt. So maybe the loan company was like, "Well, no, I'm not going to let him do this to her," type of thing. And right. And finally he came and he said, "Listen, here's the deal." And they said, "We'll do it." Like for nothing. But there was that initial, "Sure, be happy to." There wasn't that. "Sure, we'd be happy to do that for you."
Right.
So how hard is that going to be for somebody to navigate? And do you know, like, do most companies are like this? It's not the first time in the world like somebody's going to die without a will.
Right.
So there has to be procedures in place, and
right.
companies have to have seen this before. Are there traps?
It depends on how big the company is. I mean, on some of the estates I've had, working with larger banks has been a challenge to prove certain things or meet all their paper requirements, paper trails, all the things. It's tricky, even for me to do it and do it as part of my job. I can't imagine just spending my free time outside of a job doing it for a family member. I mean, it gets tricky. It gets very frustrating. Other companies are much easier to work with. So it really varies on, I think, on the size of the company, whether it's local and how simple it is. If you've got the simple papers or if it's a little more complicated, you know, like we talked about earlier with multiple death certificates involved for people who have passed and things like that. There's always a way to get it done.
Yeah.
It just takes more time sometimes.
And we'll talk about this in a little bit, like what's the airtight plan for somebody like me to go through? But it always sounds like there's some sort of red tape, paper trail, like just frustrating path.
There can be. Some of them are very simple. Right.
Can I get... So in the state of Iowa, you can't do the napkin will, but can I print a will offline and?
So you can. Again, you just have to make sure you've got those uninterested independent witnesses who don't get anything under your will. So nobody, you know, not your kids, usually not your spouse, people like that, because it has to be somebody who's not going to get anything from it. It's kind of good if you know who they are still. I mean, you don't just want to pick off Joe and John off the street, because if there's a question about the validity of the will, you have to find those witnesses.
You have to find those people again someday.
To say, yeah, we did watch him sign it, and he was of sound mind when he did that. So there's a little bit to it.
Would getting it notarized take that out?
Notary helps, yes. I mean, if you can have it notarized and the two independent witnesses, you are in much better shape.
Really?
Yep.
With just a general like template that you can pull off, and
I caution people on that, though.
Yeah, please tell me why.
Really look through it. I met with an older couple in a small town around here last week. I just met with them in their home. They weren't able to travel very well.
Sure.
And the husband said, I already revised my will a few years ago online. I did it through a form. And I said, does it match what I've been talking about with your wife today? And he said, I think so. And I said, well, if you want me to look at it before I go, I'm happy to do that. And then he hemmed and hawed, and I finished up some other things. And I said, again, if you want me to look at it, I'm happy to just take a look. I can tell you if it matches that intent or if it doesn't. It did not. So, for example, in that will, it ended up being, I want to say 8 or 10 pages, almost single-spaced, which for an older couple,
terrible.
Exactly.
Yeah.
For an older couple, it's way too long. They don't need all that in there. It put everything into a trust for his wife. Okay. And named one of his children as trustee, which they were basically naming both. They had 2 children, naming both together to act together to avoid problems. And then if the wife would pass first, it would leave 50% of the estate to his daughter in a trust until she was 50, but it didn't leave the other half to anybody. And none of that matched their intent. He just wanted everything left to his wife if he passed first.
And she can deal with it.
And she can deal with it. And then if she passed first, everything equally to the kids outright. That's simple, which is what most people want and what most people should have. And it completely did not match that. And he had no idea.
And he just found it on the internet and just electronically signed some stuff and did some things. Man.
And I think people hear that word trust and they think, oh, that can be a really good thing. That's a great idea. I should add a trust into it for more protection.
Yeah, I thought that coming into this was like a trust sounds like it just avoids all the like litigation, like just some steps. It saves you some steps instead of clicking 3 or 4 times. You click twice, and boom, my kids get my stuff.
Right, and it can, but you have to do it the right way. But you can't avoid the question of who gets it. And when do they get it? And when does the trust terminate? Those are still questions that you would have to answer similar to a will.
Right. And that makes that when you say it like that, that makes sense. Let's talk about, do you do medical power of attorneys?
Yes.
So let's talk about that. So here's what I did, right or wrong. I printed one off the internet, a general one. I named a couple. Neither one of them are family members.
Yep.
And I had it notarized by a chaplain.
That should be okay.
And then I gave copies to the 2 power of attorneys, and I have one in my safe.
Yes, that's great. You, as we get older, I mean, hopefully we're not considered to be at that age yet, but as you get older, you can give it to your family doctor, or if you have a specialist that you treat with or something. Sure. I tell people, go ahead and just give it to that person. At some age, they start asking you for it. Yeah. Have it, if you're at Mercy, Unity Point, wherever you are, have them scan it into their system so that they can see it across the network. And then in an emergency, it's already on file.
Do you have any, so I picked non-family members as mine because I wanted there to not be some sort of emotional attachment.
Right.
Not to say that they wouldn't be emotionally affected. I hope they are by my timely or untimely demise. But they also are in the business. They're coworkers of mine, so they understand the lingo. I'm not interested in a doctor trying to sell my wife hope when there is none, just for the sake of whatever. And so keeping it out of the family and giving it to somebody who understands how people talk in healthcare. Reasonable or unreasonable?
I think it's fine. I think as long as you've had that communication, if you're married with your spouse, and I know you are, but if other people are considering it, if they've had that communication so it's not a surprise later.
Yeah.
I think that's key.
Definitely no.
And I think you just have unique experience with that. With the work that you do and the trauma that you see, you can see that particular value to have that educated person making those decisions for you. A lot of people choose family members. I don't think it's a right or a wrong answer. I think the key is making sure whoever they call them agents under the power of attorney, whoever your agent is, making sure they know what your wishes are, what your intent is. That to me is the real big piece. We get into that a lot pre-hospital too, is there's out of hospital, do not resuscitate orders. Yeah.
Nobody can ever find them. And I've been, which I get it. And then under law, well, I'm sorry, unless you can produce that paper, we have to do X, Y, Z until either efforts are terminated by a physician or you present the paperwork. And nobody can ever find it. And most people are reasonably understanding to that. They're like, or you get somewhere and they say he wouldn't want this. Yeah. I understand. I'm on your team. Either do I. But unfortunately, probably because of some bad actors.
Right.
Who have said he wouldn't want this just so they could get his stuff.
Right.
And now we have to I'm sorry, you have to show me the paper.
You have to have a paper trail.
And it's unfortunate, I think. And even when you get to the hospital, like weeks on end, they will send somebody to the ICU against what they would want here on Earth. But because they don't have so without a DNR or without a power of attorney, let's say I expire at home and EMS comes in, they say, no, we're going to go. We're going to do this. Can my wife stop it because she's my wife? Can she say, no, he doesn't want this. I don't want this.
So that's where I always have to say to people, in an absolute emergency, I don't know how the medical providers will respond because somebody has to make a decision.
I think the state requires them to have and I don't know this for sure. I know for my business, there's an out-of-hospital DNR piece of paper that you can print off the state website, and you should probably have that at home if that's not what you want.
And that's what I'm saying. If you can be proactive and get those scanned in, I mean, an EMS might be a different thing, but if you can get it scanned into your normal network, medical network, so they have it on hand and you're not scrambling to find it in those moments, that will make everything a lot easier for the medical providers and for the family who's trying to work through it. But when you don't have that, or you say, I have the power of attorney, I just can't find it, but now we're in a true emergency and I'm trying to tell you I have the authority to make decisions, I think it gets tricky. I think the default in the absolute emergency for however long it's lasting, a couple of minutes, couple hours, is to go to the spouse.
Yep.
And then after that, they'll start saying you either need to go get a guardianship of the person if it's going to be a long-term medical need, or you need to find that power of attorney or whatever it is. It's only going to last for a certain period of time that you can make decisions without document or authority.
Documentation, sure. Is there any other thing, like other than a power of attorney for medical? Is a durable power of attorney and a medical power of attorney the same thing?
No, they're not. So I do like how Iowa does that. So there's usually 3 things we have people sign when they come in: a will, the living will / medical power of attorney, and then it's called a durable or a general power of attorney. That's your financial one. So the powers of attorney control while you are alive, but usually it's because you're unable to make a decision for yourself. There's 3 ways they become effective. You can make it effective when a doctor says you can no longer make decisions. So I can sign it now while I'm of sound mind, but it's not effective yet. My husband or I don't even remember his name second. My agents can't do anything for me right now, but they could when a doctor signs a note that says Kara is no longer of sound mind, or Kara can no longer make decisions for herself.
When somebody declares you incapable of making, now next in line steps in to make.
They take the doctor's note, they take the power of attorney, and they either go to the medical provider or they go to the bank or whoever it is under each power of attorney, and they start making those decisions and acting with authority. That's why I like that there's 2 separate ones in Iowa, because you might want the other people to make your medical decisions, but you may not want those same people to have financial authority over you. So there's 2 separate ones. You can name who you need to in each circumstance. The other ways they become effective, you can make them effective immediately, or you can make them effective for a certain time frame. The time frame, I think I've only seen that once, and this was probably early in my career when they were going on a mission trip. I think some of that has become null and void because there's so much online banking and online everything else that you can basically take care of your financial affairs no matter where you are right now or if you're gone for a period of time. But those are the 3 ways they become effective.
And again, do we have to have copies of that somewhere? Like you get copies of this and you should really know where they are. You
should. Again, we put them all in a folder. The originals of those documents of the powers of attorney do not matter as much as the original will. So you can take a copy to your doctor. You can take a copy to the bank, or if you're selling real estate, take a copy when you're going to the closing for real estate, saying I'm acting as agent for so-and-so. I've got authority to sign to sell this home. Yes. So copies are easier with the power of attorney.
I appreciate 2 people in life, attorneys, good ones. And
that's true.
The people that do my taxes.
Yes.
Because in order to interpret any of the tax laws or this kind of law is absolutely just, it scrambles my brain. What do you do? Divorces?
I do.
I'm not in the market. Just so we're clear.
Does Lindsay listen to this? Yeah, we want to be careful.
Yeah, she does actually. And I'm grateful that she does. She's been a very good supporter of my projects, no matter how silly they sound at the time, because I've done some dumb shit.
We all have.
With some real enthusiasm, right?
You really went for it.
And she has been like, all right, man, I'll sit back and watch. We'll see how this turns out. And some of it good, and some of it I learned some lessons.
We all do.
So anyway, I'm not in the market, but which do you think is more contentious? Will readings, will and testaments, end of life drama, or divorce drama?
End of life.
For real?
Yeah. And I don't remember if this was while we were starting to record at the beginning or not, but I do a lot of child representation. Okay. So think a little more high conflict divorce or custody actions. And I work with the kids a lot in those situations. Hands down, will contests, fights, end of life, all of those things are much harder on families than everything else.
Because everybody thinks they're entitled to get something that they don't know exists, or what?
Right, or they have strong feelings, like you said earlier, but I was promised this, or I thought I was getting that, or this isn't. It can get really tough if there's farm ground involved, and a question of if somebody's staying to farm, but other people want to sell, what's a fair value? Who has taken care of mom and dad and taken them to appointments? It gets really hard.
I believe that.
And it's hard to put a money value on some of that, so people try to put a value on it themselves in other ways.
Yeah, and emotions are high anyway because mom or dad or grandpa and grandma just passed.
Exactly.
I think there's at least we all assume, I wouldn't say all, but maybe a lot of us assume like there's just something that exists that we don't know about. And when grandpa goes, I'm sure I'm going to get, he's been hiding this money for so long, like he would never leave this earth without leaving us something. And you see it on TV all the time as people are trying to kill people for the love of God for the stuff that they think is getting left to them and whatever, and then that transfers to real life. And surely Dad had, I can see how he lived. He was very modest. There's got to be a coffee can of cash somewhere. Right. That was for me, and that just never ends up being really the case.
No.
47 minutes. We can wrap this up with, in your opinion, what is the best course of action to take for somebody still living to get ready for the end, basically, legally?
A will. I think they need powers of attorney and a will. And for us, it really doesn't change. We flat fee those things. We don't charge hourly. We do just a flat fee. You might meet with me 10 times. You might meet with me twice. We might have a phone call and meet once. It doesn't matter. It doesn't change my fees. I want to make sure you're comfortable with what you're signing and confident in it and that you're okay. But the biggest things are just to make sure it's done the right way. Can you do it the right way online? Maybe, but you really got to pay attention to what you're doing for the example I gave.
I feel like I can do my taxes online too, but that's probably
that's not a good idea.
It's probably not the best course for me to go.
I agree. And the reason I say that, you said at the beginning, people assume the only way to have an estate is, a gated property and $1 million. And that's not true. You still need to make sure that it's very clear who your assets are going to and who oversees that. And that there's just that process there to reduce the fighting, hopefully, and to make sure that it's set up the way you want it to. And it's really easy to do it. The powers of attorney are, in my opinion, just as important, because as people are living longer sometimes with some health diagnoses and they can't do stuff themselves, you've got to have those in place. You really don't want to have to go to court for guardianship, which is meeting a person's day-to-day physical needs, like where they live, medical, stuff like that. Or a conservatorship, which is the financial side of it. You can have either one of them independently or a combined. You don't want those. They're there for a reason and they're effective, but you'd rather do it a much simpler way through a power of attorney. And so if you can have those in place just to protect everyone, have authority to make decisions, it's just so much easier to be proactive.
Yeah, for sure. Really an eye-opening experience from having my dad who passed, and then having a friend of mine who's obviously younger than me, and preparing for his. And I know that we do this it's human nature, it's the human condition. It's like, I'm 48, I'm in pretty good health. I have no problems. Like, I'll get to that. Maybe when I retire, we'll sit down and we'll have the conversation about where our kids are and who gets what. But that's a myth. Right?
It is. People avoid it. And the biggest reasons that I hear people avoid it are when kids are young, it's really hard to think about, let alone decide who should be the guardian of the kids. If we have to have somebody step into mom and dad's shoes because we're both gone, who are they going to live with? Who's going to take care of them? They try to avoid that because they either can't agree or they just don't want to think about it.
When I grew up, I used to hear that the godparents got the kids.
I know, right?
That's not true, right?
It's not. No,
it's not true.
It's not true.
When we got baptized, it was, what are we doing this for? And why is so-and-so here? And it's like, well, if we die, then you're going to go live with them.
Right? I know. So that's a big avoidance right there when kids are young. But it's just as true when a couple's older, like maybe when your parents were older. Sometimes people avoid it then because they don't want to offend their kids. Well, I'm choosing this one person, but I'm not choosing the other 1, 2, 3 kids to do anything. I don't want to hurt their feelings. And people just need to maybe not worry about that because they'll be gone. It's not their feelings that are hurt anymore. They don't have to worry about it. Yeah, they just need to choose people and do it to be protected.
Yeah. And I don't think, personally, I think people don't want to, we're all going to get to the same place. We're all going, right? Like, it's inevitable, but the thought of it makes it seem like, number one, that's a long ways away, so why would I worry about it now? It's kind of like doing the laundry. I don't need that shirt till Wednesday. I'm not going to do the laundry now. And then, so the facing your own mortality, which is what you do. And if the laws of nature work right, my dad passed, well, I'm next. I was on deck, and now I'm up to bat. And if the laws of nature work correct, my kids will be on deck. But we don't necessarily know in what order that's going to happen. And that was a big thing. And I was really kind of surprised that my dad had his stuff. It was a generic, kept it in the safety deposit box. It was a generic will. She had lawyers looked it up, and it was, if my living spouse doesn't want to do it or she's not around, then I get to burden that thing, which wasn't terrible by any means. Where can people contact you? How do they get a hold of you? How do they make you their end of life attorney? Is that a thing? What's the terminology? You're just a family practice firm?
Yep. As an office, I've got 2 guys I work with here, Jamie Burkamp and Matt Hemphill. We're a small office here in Adel. We try to cover most areas of the law. We don't do taxes, so don't come to me for that.
Don't cover.
We don't do that. We don't really do any criminal work, but otherwise, among the 3 of us, we try to spread out and cover most things. We all do estate planning, so anybody can call us here at 993-1000, or they can look us up online. Any of us would be happy to talk through.
What's the name of your law firm?
Burkamp, Hemp Hill, and McClure.
Yep. Here in
Right on the bike trail, right, Nadell?
Right next to the library where I used to go all the time, or I still go all the time,
right.
To get books with my kids and for me. Is there anything else is there anything else we left uncovered?
I don't think so. I think, I just emphasize that proactive part, just being proactive instead of being avoidant on it.
And really probably just hire somebody to do it. Like it doesn't, unless you're savvy. I'm not savvy. I would eventually will probably end up coming to you and saying, all right, here's all the debt. Oh, that's the other thing. Who gets, let's say real quick, credit card debt.
So if there's an estate.
Who inherits that?
Hopefully no one.
Yeah, right.
So what would happen then if there's an estate being probated is then you give notice to the creditors, and then they have the right to say, MasterCard has the right to say, okay, Kara died, but she owes me $100,000. So before money is paid out to the beneficiaries, I'm making a claim on the estate that you have to pay me. Yeah. And there can be some negotiation with that and other things and see how that was really acquired, the debt, and whose name it was in and stuff. But that's how the process would start.
And that's clearly
my kids aren't paying it,
right?
But they may not get what they thought they were if I
the
have
whole
other
estate
debts.
is worth $500,000. That may not get disseminated the way they thought. They're gonna take off the top first what mom and dad owe,
right?
And then you're gonna get what's left over.
Generally,
yeah. And that negotiation between the estate and the creditor is done through attorneys,
right?
Yeah. So just the lesson there, I think, is just hire an attorney.
I think so. And if you meet with somebody who's reasonable, like you said, find a good one. I don't mind if you did something online and now you're just not sure if it looks good, if it meets your needs, if it's overcomplicated, if it left things out. I'm happy to look at things with people because I'm the type of person, I just want to make sure you've set it up correctly.
Right.
If I think it's done well and you're fine, I'll tell you that. You don't need to do a new one through me.
Sure.
Just make sure you got it done.
Yeah. Listen, I really do appreciate it. And I know that everybody listening, all 6 of them, are, that's not true.
7? Maybe 7?
I might get 8 out of this one.
That's a good one.
If I advertise it right. I still don't know how to get traction on Instagram. I try to post stuff and then I get 3 likes and I'm like, but there's 100 followers. How is only 3 people liking this?
What happened to the other people?
Right. I'm just trying to show that we got a show, man. And so
anybody who knows me knows I can't help on social media. So
yeah, I'm not big on it either. But I do know that I got to be getting somewhat big because I'm getting phishing emails from producers that are saying, "Hey, congratulations on all 20 episodes. Would you like to hire me as a producer and we'll just take this thing next level?" So that's how I know I've hit big time.
That's right. That is big time.
I really do appreciate you sitting down with us. It's great. It's probably going to be one of the best informative episodes yet. So this will publish on July 8th.
Fantastic.
So
thanks for having me.
I'll send you a link.
That'd be great.
All right. Thanks.
Thank you.
Hey guys, thanks again for listening to another episode of the Shift Change Podcast. I need to ask if you would leave a rating. I think that it helps people who are new to the podcast find it quicker. It doesn't do me any good, but it does help other people that are looking for the Shift Change Podcast on Spotify or Apple. It just comes up quicker the more ratings that you give it. Whether you give it a 2 or a 5, it doesn't make a difference. It just helps other people. If you need to get a hold of me, contact me via my email, the show email, which is talkshiftchange@gmail.com. Or you can message me on Instagram at talk.shiftchange. At talk.shiftchange on Instagram. As always, thanks for listening. I could not have imagined how well this podcast has been received. So, as always, I appreciate it. Work hard, be kind.